Okay, now we're ready.
Okay.
Good morning, good afternoon. This is the Board of Standards and Appeals Public Review Session for March 23rd, 2021, the 2 p.m. session. No public testimony is permitted during the review session. The first item up is a zoning calendar, new cases, item 24, 2020-55 BZ, 1284 East 19th Street, Brooklyn.
Okay. So we have proof of service of initial application to officials and of notice of hearing to officials and neighbors. Community Board recommends approval with 4 abstentions, although the reference is to a special permit. So it isn't clear to me what the applicant described to them, and I don't see submitted into the record the required submission to the BSA of the materials that were presented at the Community Board. That's actually a requirement of local law, so they must submit what was submitted to the Community Board. With respect to the A finding, I don't think there is any question that this zoning lot is unique with the side lot lines proceeding at an acute angle from the street line, or with the lot lines proceeding at an acute angle. It seems like it's only the other sites on this block that have that kind of angle condition. However, I disagree with the analysis of the lot lines. I think that, and Kurt, could you display that image? So on the left side, well, I'll say on the right side, that's the site. And on the left side is section 23-543, which was specifically created to deal with flag lots. And this is clearly a flag lot where it has more than one lot line that either backs up against someone else's rear yard or someone else's side yard, depending on how you interpret, well, not interpret, but how you study the lot lines of the adjoining properties. So when I look at the adjoining properties, I see rear lot lines. So it's backing up against rear lot lines. And this flag lot was intended to deal with this reality that you need to provide a 30-foot rear yard up against someone else's 30-foot rear yard. And then there's another diagram that shows that if you're backing up against someone's side yard, then you provide a 8-foot side yard. I think it was 8 feet side yard up against that. So, and this regulation was intended specifically for a lot like this one. So, so what I think is for one, that you need to go to DOB and get a ZRD1 that is written very specifically to argue in favor of this interpretation for this tax lot, for this zoning lot. Because if you do that, then you can build the project as of right. And in fact, when I did the analysis, applying what is shown in the diagram in 23-543, I started to figure out like how much you could develop on the site. And first of all, the site, the architect is assuming that you have to have a side yard for the side yard regulations, but there is no side yard regulation as of right in an R7A. It's either 0 or 8 feet if you provide any. So you can actually build right up into the side lot line. So when I do that, I get, for example, I get what turns out to look or more or less exactly like the proposed drawing, except that I fill up the project with all the way up to the side lot line. And so what I get is, instead of the 12-foot wide strip house, I get a 50 by 56'7" plus a 25-foot by approximately 70-foot section, which adds up to a 4,600 square foot floor plate. So that's much bigger than what they're even showing on their proposed. So I get that as an as of right with the flag lot interpretation. So, notice to the owner, who I hope is listening to this hearing, you really don't want to be the subject of a BSA variance if you don't need to be, because as we always say, our adage is once married to the once you're at the BSA, always at the BSA, like a marriage, only you can't get divorced once you take advantage of these waivers, right? So it would be very much in the interest of the owner for owner's counsel and architect to go to DOB and argue that this lot qualifies as a 23-543 flag lot. So, okay. On the other hand, let's just say the architect's interpretation is correct. Then the as of right is still incorrect, because it should be revised to, you can take down the share screen unless people want it up. Thank you, Kurt. The as of right needs to be revised to eliminate the side yard along that clear side lot line, and a clear side lot line is one that is intersecting a street, right? Since it isn't required, and then the floor plans need to be provided to show the resulting layouts and financial analysis. You can't just show a site plan and say it's just not going to work, because it might actually work. You get to build full to the 25-foot width. I think it's 25 feet for that skinny part. You get to build all the way back at 25 feet until you get to whatever that lot line is that I'm calling a rear lot line. So that's a very long, narrow building that's typical of lots of buildings built on 25-foot wide lots. I mean, New York City is filled with 25-foot wide lots, right? And this is a very deep lot. It's, I think it's 148 feet long at the sort of the shortest line, that is side lot line that actually touches the street. So also the analysis for rear lot line is the extension of the rear lot line until it intersects the street, and then a determination on its angle at the intersection, which isn't shown on the drawing. We see all of the other angles, but we don't actually see the angle of intersection of what would normally be your rear lot line. I mean, you can do the math and separate and add the numbers up, but we don't actually have the most critical angle, the one that is determining whether this is 45 degrees to parallel. Also, I didn't find a discussion with respect to the D finding and whether this lot was held in common with adjoining lots. Only a single 1965 deed for lot 31, which is the subject lot, was provided. We need a search of all lots that are adjacent to it, lots 72, 24, 33, 40, and 35, to see whether since 1961 they were held in common with lot 31. And of course, I never just sit back and say, give it to us, because most of the time we don't actually get what we ask for. So I did the research. In fact, they provided what was called a linen tax map, where they said they don't give us the production date, and they don't refer to it in the statement of facts. And it is, after all, one of the findings. You're supposed to go through the precedential ownership. But it shows that in 1966, Lot 72 was subdivided from Lot 31, and Acris shows the two parcels were sold to different purchasers in 1966. So arguably, a predecessor in title created the hardship complained of, and the way around that would be to show, which you're not going to be able to, that even if that lot it's a through lot, even though that through lot was subsequently subdivided, it wouldn't have made any difference. You still would have needed the same waivers. You're not going to be able to show that because the through lot lines continue all the way to a street, and that makes it a side lot line. Also, there is also recorded against lot 31 a collection of zoning lot development agreements that cannot be ignored by applicant's counsel and must be explained. They include a diagram of the subject tax lot. So that makes it look like that the subject tax lot is part of a larger zoning lot, and either they sold their development rights already, or they became part of that larger zoning lot, in which case you cannot look at this as a standalone tax lot, because somehow the development next door relied on this zoning lot, and you need to explain how. You know, I could dig through the Zeldas, but it's not our job to figure out what those documents mean. A 2017 deed shows lots 31 and 33 conveyed together to the current owner, which is 1284 Plaza LLC, and that isn't mentioned anywhere in the statement of facts. And so we don't really know what lot 33 is or what it does to it, but it apparently was conveyed to the owner of this lot. Another document, another document shows the prior owners of lot 31 as owners of all or part of lot 136. So what does that do to the predecessor in title creating a hardship complained of? And I have to say that, having discovered so many things on ACRIS, which takes 2 minutes to discover, you open up ACRIS and then you see recorded against the subject lot and adjacent lots, you see documents that could impact the predecessor in title self-created hardship issue. And I have to say, I'm not happy at all with what I see as an attempted obfuscation of facts, or requiring that this agency conduct its own title search to uncover them. That I find that really troubling, that that's what's happening here. So I think you have two significant problems with this case. So I didn't go into any of the other issues. I think there are too many problems with the A finding and the D finding. So, or not even the A, the threshold. So what's the hardship complained of? I actually don't know what it is, if it's a flag lot. So, and the as of right not being accurate. So Vice Chair Shanda.
I have exactly the same set of concerns, and I will take it a step further. In first blush, yes, it looks like a unique site, okay? But I question the way the rear yard is being analyzed. Not, you pointed out the flag lot and the rear yard that would be required, assuming lot 33 was held separately and is not part of the same zoning lot. You would need a 30-foot rear yard behind the lot 33. What I am also questioning is the way the rear yard is being analyzed along the lot line. That is not the northern, the southern lot line. I don't think that qualifies as a rear lot line. The way the zoning is being read, it says a rear lot line is any lot line of a zoning lot except a front lot line, which is parallel or within 45 degrees of being parallel to and does not intersect any street. I don't think after that jog of the lot, of the side lot line from the front as it moves southward and then again further goes west, that portion I don't think qualifies as a rear lot line by that definition. So I think a ZRD review is definitely needed, not just for the flag lot, but also the way the basic definition of a rear lot line is being applied on this site. The way I see it per zoning regulation, definitely a flag lot rear yard of a 30-foot would be required behind lot 33. And then, Madam Chair, with regards to section 23-471, it talks about that in an R6 and R10 district, no rear yard will be required where such rear lot line coincides with side lot line of an adjoining zoning lot. Because this is an R7A, therefore they do not require an 8-foot rear yard abutting another side lot.
Right, yes,
Right.
that's if it's a side lot line. Yeah. Thank
Right,
you for pointing that
right.
out.
Now,
What was the section again?
it is ZR 23471.
Right, correct, right, okay.
Now, what is frustrating about this application is I also made the same as of right analysis that you did, which is why are they providing an 8-foot side yard? Then when I went through the drawings, I noticed there's a dashed line and it says easement.
Mhm.
And this is a fire easement. So because they have to maintain this 3-foot fire easement, the zoning requires you either provide 0 or 8.
Mhm.
So that is why they're providing it. Nowhere in the statement of fact that is at all stated. And if that is the argument, that needs to be brought up upfront. The easement document has to be provided. We need to clearly know what is the extent of the easement volume, horizontally and vertically, and how and all the documents to justify that there is an easement and that easement is in perpetuity and needs to be maintained, and therefore a side yard of 8 foot is required. So if that is the premise, then we start with the discussion. Then my question leads to the next thing is, why isn't the applicant seeking a special permit under section 73-69, which is a rear yard modification? Board of Standards Appeal may permit modification of a rear yard pursuant to all the zoning regulations that we have due to the irregular shape of a zoning lot. That is provided they're able to provide an argument through the ZRD test. I don't think, since they're not seeking an FAR waiver, height and setback waiver, they're not seeking a side yard waiver or front yard, it's only the rear yard, and there's a special permit, not even a variance, a special permit allows it. Why isn't that being looked at?
Good point.
So those are so I don't even think we can get to the 1, 2, or 3, any one of them. And I agree with you with the D finding. Lot 33 is in common ownership, and and that will cure some of the hardship. So that needs to be exercised. That's all.
Great, thank you. Thanks. Commissioner Ali Brown.
So I agree with both of you that this is really a case with the threshold A finding, and that has to do with the history of the lot. I think the tax lot history with all the surrounding lots and how they came into being is warranted here, and also a DOB interpretation of which is actually the rear lot line. Because like you said, if it is the lot line that's further back, I guess the westernmost line of the lot, then they would not need to be here because they have such a deep lot that it wouldn't be a hardship to put a rear yard there. Other than that, I really had no other questions. I think if it passes the A finding and we go further, at that point, I only have one question about the financials, which has to do with the high construction costs, considering that there is no subsurface issues. So unless they could detail that, they should decrease the construction costs for the as of right. That's it.
Great, okay. And yeah, I think we're far away from having to review financials if we ever get there. Okay, thank you. Commissioner Shaita?
Thank you, Chair. We already did. I looked at the financials, and I agree with Commissioner Ali Brown that the construction cost is kind of high. If it passes the A, I would like, and think of that with me. What I'm thinking of, if we get variance cases in the future and there is no hardship associated with engineering construction means and methods. That means that this building should like comply with the standard cost per square foot for construction within the city. So when we hit a construction cost like the one for the subject application, that's telling us that the construction cost is more than 350 per square foot. What I would them to do is, if it passes the A, just grab construction cost per square foot from one of the standard textbooks or one of the, based on something standardized within the city or within the area under consideration, and then add to that the site value and complete your pro forma. And I did do this exercise for the subject site. And if you do so, we gonna, if what I did is I took a standard cost, like say $200 per square foot, and I added that to that, and I reran the numbers in the pro forma, and what I got is actually about 100 times return than what is being claimed right now. So if we pass the A again, we're not willing, I'm not willing to like go over tons of pages, construction cost, and argue with them. Just submit to us like an evidence that you picked a reasonable number and give us a number per square foot, and we'll take that if it is reasonable. The other thing, I was wondering if it was any BSA history for the subject side. I didn't see him like talking about that in the statement, and I would like them to mention. That's all what I have for now. Thank you.
You mean, has the BSA had a case on this site before? Is that what you mean?
Yes,
Oh,
yes.
Okay. Okay, thank you. Commissioner.
There is, I'm sorry.
Yeah.
There is a reference, I'm not sure if you saw that, there is a reference on the drawings to a diagram. It says reference diagram on Z-002. Is this something that I'm not aware of? What is Z002?
Okay,
If you look at BSA-002, for example, in the as of right, and 003, it references Z-002. I'm not sure what is that.
okay, thank you. Commissioner Shabeta?
Thank you. I reviewed this application. I had some of the similar questions. I think that the threshold question is very clear. I think this hearing should really be about 6 minutes in which they'll tell us that they're going to attempt to reconcile the documents on ACRIS with their statement of facts. And I think I need to, for me, I don't think, I'm not interested in hearing much other than whether or not they get this A, and I'm not going to be convinced with a hearing on it. I want to see it in writing, and I want to be able to put the paper against, look at the names and put the paper against the statements that they're being made. This isn't something that I think a very verbose and long-winded hearing is going to resolve for me.
Right. Appreciated, and I agree. I mean, we're at the A, we have two critical questions that need to be resolved, and that's it. And they can't be resolved in front of us. They have to be resolved by research and submission to DOB and revised drawings. So, okay. Okay.
Move on.
Yeah.
Item number 25, 2020-76 BZ, 8902 Fifth Avenue, Brooklyn.
Okay. We have proof of service of initial application to officials and of notice of hearing to officials and neighbors. The community board recommends approval with 1 opposed and 1 recusal. This is an application for a 7319 special permit to operate a child care center at the site in a C8 district. I believe it's C8, right? Yes.
C82.
C82. The threshold question for this type of school use is that it holds a permit to operate a child care center under section 47.03 of the New York City Health Code. Since the center is not yet operating, it needs to demonstrate that it will meet the criteria for a 47.03 permit. Applicant provided a permit for another location in Brooklyn held by this operator that has capacity for 111 children, and went through in the statement of facts the Article 47 requirements. The other threshold question has to do with the site search. This time, unusually, there is a broker's, unusual because we've been struggling with this on several applications. So this time there is a broker's letter indicating 3 other potential sites were identified, but no information was provided about them other than to say they weren't viable as out of the catchment area or too close to existing schools, or not yet, or the building itself was not yet built and they were looking for a built facility. A submission was also made on September 25th of 2020, which includes setups for 2 sites not mentioned in the broker's letter, 9201 4th Avenue and 437 88th Street, that turned out also to be in the C8 district. So it's kind of a, let's say, haphazard submission on this because there were sort of different pages floating around and not all put together into one submission. The site is across the street from an R6B zoning district where the use would be permitted as of right. Calculations for trash and refrigerated trash room were provided for shared cellar trash storage room, but I'd like them to explain how the trash will be collected from the childcare center and brought down to the cellar if there is no direct access to the elevator or stairs to the cellar from the kitchen. It's a very, very circuitous route. And I doubt seriously that school staff is going to take advantage of that. Also, as we see so much on these childcare centers, strollers are a really big issue. And I didn't see any place for stroller storage. They need to show on the plans the number and age of children and teachers in each room. The chart provided on drawing 3 doesn't include room numbers, although it does indicate the number and age of children and teachers, but you can't tie it back to the rooms. So there's a disconnect there. Also, I'd like to understand how children are taken into the play area at the side. It appears to require them to exit the building and go back into the play area. So that means they're coming onto the streets, onto the sidewalk. And also, or either that, or they're going through the fire stairs. And I don't know if Chief Daly, I don't see him on this call, maybe he is. Yeah, I don't think he's here on this. They're going through the fire stairs to get to the side yard, which is labeled as for emergency use only with a panic bar. Also, that same fire stair is the second means of egress, which requires access through an unoccupied room. So my question is any of that part, the idea that maybe you're accessing the side yard through a fire stair, and the other that you're accessing the fire stair through an occupied room, are either of those things permitted by fire code? Furthermore, I think they're talking about using this side yard for play. That appears to be the only route of egress from the fire stairs. So when everyone else in the building is running down the stairs in an emergency, you have a play area where we know it gets filled with little like plastic houses and toys and things like that, and creates an enormous fire hazard. So how does the daycare keep this path clear of toys and children, not to forget the children, in the event of the need for emergency egress when everyone is in a state of panic? I actually don't understand how that could be allowed. Also, how will the building elevator be restricted from allowing access to the childcare floors? There was no mention of that. Is it permitted by fire code also to prevent access to the subject floors from the fire stairs? How, for example, would fire department access the floors? Same goes for the third floor fire corridor. So I would like our project manager, who's this? This is Jella, to forward these questions to Chief Daly, and or have him at least listen to the video and perhaps respond. I know that some things are not handled by the fire department per se. They're handled by the buildings department, but to the extent that fire department looks at this, to ask them. But the other question is for the architect to respond, because I'm not sure any of this is allowed. Also, the biggest issue for me in the application is probably the impact on traffic with the private car drop-offs. I didn't see any traffic study in the seeker documents. In fact, so far, I don't think we have an EAS in the file. And perhaps also student safety with respect to possible access to the center by other building tenants, the childcare center by other building tenants. I see Tracy's hand up, just one second. So also we would need a noise study for the outdoor play area and air quality to take into account the use of the outdoor play area. And I have Tracy's notes, but she has her hand up, so she might as well say. Go ahead.
Yes, we did receive a draft EAS, not fully complete, but we did send it to DOT and DEP for hazmat, and we're waiting for the air quality analysis to be complete and noise.
Okay. I don't know that the EAS made it into the folder. That's why. Otherwise, I would have looked for traffic. I doubt it has
In
it.
the seeker folder. It's in
Yeah.
Maybe when I looked, it wasn't there yet. So, okay.
It's from February. It was submitted in February.
Right. Okay. Well, whatever. It didn't download or something when I looked. But so does it have a traffic study at all?
It did have traffic, yes.
Okay. So I didn't see that. Okay. All right. So Vice Chair Shanda.
Thank you. I will add to what you have stated, Madam Chair. In the site plan, the applicant should show the location of the parking entrance. There is a parking in the building, so I just want to make sure where it is located in relation to the daycare entrance and the playground. That's all. That's the reason for it. During the morning drop-off, my most remaining questions are related to traffic. During the morning drop-off, it is possible that there is likely to be adequate curbside parking spaces. However, during pickup, the on-street parking spaces are very much going to be occupied. This is a very active street. The street frontage, it's a busy commercial corridor. I would like more clarity regarding the afternoon dismissal and its impact on the local traffic. I had similar question with regards to the outdoor play area as to how it was going to be accessed. And will there be any acoustical noise barrier along the fence? That I think there is space for a stroller area in the reception area, but that the applicant needs to show that. And I had same question regarding the trash, how that would be accessed. I'm assuming it would be via the staircase, but that's a messy transition.
Right. They're dragging trash down the fire stair. I'm not sure about that. And otherwise, that one interior stair would end up in the parking garage, like right in a space. So I'm not sure how that would work if they extended the stair down one more level. They really should be doing is extending that service elevator down one more level so you could actually bring the trash into the service elevator. But anyway, the dedicated elevator for this use.
Yeah, I think it will affect their parking layout because it will be right smack. Yeah.
Yeah.
And they probably are providing whatever they required in that tight space. So,
Right.
but there could be another way. So just relocating the trash thing closer to that so that it makes it easier from the even, or
Right.
a chute. I don't know.
No, but then you have to, yeah, if it's true, a trash chute that goes right into the trash room and then the
Yeah.
building takes it out to the street. I mean, it's not clear to me who's going to handle it. It's in a very
Right.
remote
Yeah.
location.
Yeah.
And there's, and I don't know if the elevator goes down there, but anyway, that building management would have to take care of the trash. So that's not clear. Okay, thank you. Commissioner Ollie Brown.
I had no additional questions for this applicant. I actually was fine with the traffic operational plan that they had, simply because these children are so young that they will have to be escorted by a parent or guardian. And so I thought that it was, as long as they ensured that a parent or a guardian must escort the child into the building and must go into the building to escort the child back home, that's all that mattered to me, and they're assuring that that's what's going to happen. As for where the parents can park, you know, that really, to me, is up to the parents. If they can't find a spot on 89th Street and they have to walk 3 blocks from whatever parking spot they have, they'll either make that sacrifice and park and walk the 3 blocks, or they'll go find another daycare. You know, as long as, to me, the children are protected, that's key. I don't think that they're going to be able to double park on 89th Street. It isn't that wide a street. So it's not like they're going to be able to get away with that.
Mm-hmm.
So that's basically how I feel. I'm okay with this application.
Okay. But why couldn't they try to double park?
They could try and double park, but it won't be very hard for the community to actually get the councilman to get DOT to just ticket people. And all you need is a few days of tickets and nobody's going to park on 89th. Now, if you were to double park on 5th Avenue, that's a 2-way street. It's a wide street. You could get away with it, you know, but it's going to be on the risk is going to be on the parent, whether or not they want to risk a ticket.
Yeah. They really would be parking. It's not like they would be dropping off because you have to escort the kid.
Right, because you have to ensure that you go into the building.
Right. Okay, thank you. That's helpful. Thank you. Commissioner Sheta?
Thank you, Chair. The comments I have are related to mainly 2 things. Number one, the search criteria that they provided in the statement of facts. They said they looked at buildings with available floor area of about 1,400. Actually, they said 13,482 square feet, roughly. And I'm not sure what this number is based on. I understand this is not a variance, but do they have like an estimate or a programmatic needs that they prepared and came up with this magic number? Because if this is a governing criteria for the search, probably if they look for a 10,000 square feet building, they might find 1 or 2. And if they look for 15, they might find 1 or 2. So I just was wondering where from this number came. And the other thing is, again, related to the search criteria, that they said our budget for like the buying space is a price between 28 and 36 square feet. And again, I was waiting for a justification for that price range, but I didn't see any justification. So if, let's say there is like 2 or 3 buildings available, but they are like $45 a square foot, are these 3 or 4 buildings reasonable price wise? If they are, I believe then we have a different situation here. We have buildings that are available in a district where the use is as of right. So I'm looking for a justification for that $28 to $36 per square foot range. Regarding the parking, I was like flipping the drawings because this is one of the points that you look at when you look at an application like this. School and a parking garage in the cellar. And I was looking at the floor plans. The cellar floor plan does not like indicate where is the access to the parking. And I was wondering whether it is from the like the side yard. Is it from the side yard? Maybe. And if this is the case, they have like identified an emergency exit or a second means of egress through the stairs. This is to the north, I would say, or it's on the north of the building. So if these two stairs are going to be used as second means of egress, I'm not sure would whoever is want to leave the building would exit to the first floor, or maybe he's going to exit to the cellar. This is not clear. So I believe they need to clean up the drawings with regard to where is the access for the parking and how the second means of egress is going to be worked. That's all. Thank you.
Thank you. Okay, and Commissioner Shabetto.
Thank you, Chair. I've had some similar comments that were already mentioned. The only thing I would add is I do see a problem with the potential double parking on 89th Street. In my experience, parents blocking up a lane of traffic or a street of traffic so they can drop the children off is not something that I haven't witnessed personally. This is, and I think we've had cases in the past where this was one of the major complaints, that people are just leaving their car and moving the children in and out of the school. So I'd like to hear the applicant address that and see if they can come up with something that makes a better flow for the drop off of children.
Mm-hmm. So, and you're saying that they double park and they run in with the kids and then they run back, basically.
I am.
And here comes the bus along Fifth Avenue. That'll be charming. The city
Right.
bus coming along Fifth Avenue.
I'm less worried about it on Fifth Avenue than I am on 89th Street.
89th Street's narrow, yeah.
I think on 89th Street and it isn't as heavily trafficked. So I think that's where you'll find more people just dropping off, stopping the car, running out, and even on pickup, I wouldn't be surprised to see that street just not circulate.
Right. I'm looking at the site plan. The entrance to the parking garage appears to be from Fifth Avenue. There's a curb cut there, whereas there's no curb cut on 89th. So that's arguably far away from the entrance to the daycare. But of course, because they don't show anything more than that, like they do show that, I think that's an elevator, though it's not labeled that way. There's sort of this box that's on the Fifth Avenue frontage with sliding doors. That's probably the car elevator. But because the drawings aren't well labeled, you sort of have to guess that.
Yeah, I think that
I think there's an elevator
I know
there.
that from the reading of the drawing, but it needs to be clearly indicated in the drawing
Yeah, I think
from the
there is an
perspective of the
elevator.
daycare. That's it.
Yeah, it says over next to the box, it says car lift mechanical room, but it doesn't tell you that thing is actually the car lift. So, yeah. Okay. And the first floor plan also doesn't label the car lift at all. It's like no clue what that box is. So, okay.
Tracy.
Tracy, you have your hand up. Go ahead.
Hi, I was reviewing the EAS, and the applicant had previously indicated by email that the air quality analysis was not complete yet, but it appears to me that it might be complete in the February EAS. So if they could confirm if the AQ and noise is complete, so we can send to DEP.
Mm-hmm. Okay. Air quality and noise. Okay. You're right. Thank you.
Thanks.
Everybody done? Okay, this concludes the public review session. We will now commence with the public hearing. So now we're in public hearing. This is the public hearing for the Board of Standards and Appeals for March 23rd, 2021, 2 p.m. session. First item again is zoning calendar new cases, item number 24, 2020-55 BC, 1284 East 19th Street, Brooklyn.
I want to add on this, during a review, I don't think we mentioned that there were objections, letters of objection from one person who lived in the rear of this.
Oh.
of this lot.
I don't know if I saw it. Okay. Okay, my computer just crashed. Wait.
Good afternoon.
Hello.
Hi.
So it's
Todd,
Todd, Elise, Barbara, and who else?
yeah, Elise is here.
Barbara Cohen.
Yes, I'm working with Eric Platnick's office.
Yeah, I know.
Oh, I didn't know. Okay.
Yeah, there was a letter or an email, I think, that you were co-counsel, Todd, right?
Yes, the
There was a letter.
we got an additional owner's affidavit.
Yes.
Is where
If you're a member of the applicant team and you're waiting to be let in, please raise your hand in Zoom.
yeah, I'm not sure if anyone else is going to be here.
Okay, let me swear you in anyway.
Okay.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do affirm.
Barbara, Elise?
Yes. Can you hear
Yeah.
me?
Yeah.
Yeah.
Okay, go ahead, Todd.
So good afternoon. We did listen to the review session and the comments that were raised. I will just start by saying it will be much easier to review some of these issues in a written submission. So we will make a written submission in response, but I will just briefly speak to some of the points now and sort of set the table for the upcoming submission. First, we would agree to provide additional information with respect to the A and the D finding, but with respect to the A finding and some of the discussion, just to give the board some history, the project architect, we're very aware of if we could do this as of right, they would be preferred to do it as of right. And the property owner and the development team did try and proceed as of right. It was Department of Buildings that actually set forth the determination as far as these being rear and side lot lines. And there was actually initial discussion of filing for a ZRD1. And Department of Buildings actually informed the project architect, don't bother, because it's going to have the same interpretation. Just to clarify, with respect to 23-543, that applies to lots that have multiple rear lot lines. And because of the orientation of this lot, because it has an angled, the best way to describe it is because the street line is angled and it's not straight, there is only a single resulting rear lot line. And because it's a single rear lot line, 23-543 does not apply. And correspondingly, the special permit that Vice Chair Chandra referenced doesn't apply because 7369 only allows for relief from 23-543. Looking at the proposed plans, it's only the southernmost lot line that ends up being a rear lot line. And because it's the single rear lot line, that's why we can't take advantage of those provisions.
And so with respect to this whole thing, we have not been party to DOB, how the argument was made to DOB.
Okay.
Right? So there are lots of ways, as you know, to present an argument to DOB. There's the sort of weak way, and there's the sort of argumentative way where as sort of zoning council, you go to them and you say, obviously, this section is intended to handle this issue. And to really sit down with them as opposed to essentially write it write their objection for them, right? So not privy to at all how the architect had this conversation. I would want to see a ZRD1 that we review to make an affirmative argument for this being a flag lot subject to 23-543.
Understood. Our office wasn't originally involved with that. I would tell you not to take away an opportunity for us to discuss something, but if we could do this as a right, obviously that would be easier both for the property owner and the board. So we'll go back, we'll review this with the project architect, we'll work with Department of Buildings, and we'll see if that's an option. Because if it is an option, you're correct, then it makes the variance moot. But if the language is presented in a strong manner and we still get the same determination, then we would proceed with the next steps of the application.
So, so that's you have a problem with the next steps, because I think you actually do have a significant definding problem. And so it's a serious issue, right? So, so that is an element of what would be discussed with DOB, because since those two lots, 72 and 31, were held in common, and the hardship complained of, i.e. that what we're calling on the flag lot, the central rear lot line, would no longer exist, right? So then you would no longer have to pull back from. So then you have side lot lines because they continue all the way to the street, and there is no side lot rule, right?
Understood. Yes. So with respect to the definding, we'll review the issue, and it all goes hand in hand. But with respect to the definding, just to let the board know, we'll provide a single and separate searches, as required with respect to the lots to the southeast. Just the board's aware, we knew that this would be something, but when this application was being developed, it was at the height of the pandemic, and there was really limited access to old finance records, but that shouldn't be an issue anymore, so we can proceed with that. But the flag lot condition, at least as far as East 19th, which is really what creates this whole rear yard situation, in theory, has always existed. We did provide the deed, but we can provide additional information. We can provide more information as far as the ownership. And then we can also address the lot 72 and 31. We're very aware of the issue that you've raised with respect to it being a through lot. We would note, though, that there is a building that's on the lot that has a certificate of occupancy that was issued by the Department of Buildings for a building that's actually currently within the rear yard area. We'll see if we can get more history as to that particular.
Right, but so what does that have to do with anything in your proposal, right? So, yeah, because also the common ownership with lot 33 moves your so-called flag or rear lot line, or whatever that thing is, side lot line, down further. So then it's sort of, I think it
actually, if lot 33 were part of lot 31, the rear lot line condition would still exist. It wouldn't resolve the issue, because you still have the portion, the condition, to not to oversimplify, but the condition is created by what is currently, I believe, lot 35, but it's the portion where it doesn't have the full street frontage on East 19th. So even with lot 33, if it were part of lot 31, it wouldn't resolve the issue. You'd still have that would be within the rear yard extension, I guess is the best way to describe it.
All right.
So, I mean, the short of it is we will provide additional information. We've heard all of the discussion. We'll do the single and separate search for those lots. We'll address the 72-31 issue. I would just want to note quickly, though, there were some comments about the Zeldas. We'll include information, but the Zeldas, just there's no Zelda that actually affects lot 31. Reading back through it, there is a Zelda that is in the bin at the Department of Finance under lot 31. But if you read the actual document, it doesn't have anything to do with lot 31. It only has to deal with the lots to the south. So we're not sure why it was recorded in the wrong bin at finance, but we can highlight the actual lots that are referenced in the document that don't have anything to do with lot 31. And then also, upon information and belief, that Zelda that affected the lots to the southeast, there was actually a subsequent document that rescinded the Zelda. So we can provide that information and highlight those lots, but there's twofold issues going on there. One, that it was rescinded, and one, it was misrecorded against lot 31. So
Well, yes and no. So look at the last names of the owners of lot 31 and the last name of the developer of lot 35, and you'll see why it was recorded against lot 31. So it's all in the family, and therefore it calls into question, again, the common ownership and maybe negotiations that went on and so on. So be really careful, because we review this very carefully, right? So you need to be as careful as we are, more careful.
No, I understand, and we'll include those documents and point out the lots to which they refer.
And with respect to the ZRD1 that you're going to submit to DOB that affirmatively argues that this is a flag lot, we'd like to see the argument first before you submit it.
Okay, I can discuss that with the project architect and the owner.
Okay, good.
Just a few other quick comments. The community board, I don't know why they reference it as a special permit. It was always presented as a variance. I think it's just, with all due respect to community boards, they often call special permits variances and appeals to general city law special permits and whatnot. Nothing was presented to the community board that wasn't in the original application materials. So there was nothing additional to certify to the board. So it's purely a terminology error on the community board's part. We did hear the comments about the construction costs with respect to the analyst, and we can review that. I realize that that's secondary to the primary issues, but we can address that if we reach that point. I think that those were the key items that were raised.
No, also the as of right and the issue of that easement, whether or not it's really driving the requirement for an 8-foot side yard, because it looks actually yet another self-created, arguably, and the easement, which I don't think we received a copy of, the easement may not even be valid anymore because it looks like the neighbor may have already ignored the easement. So in which case the court would say, well, those guys did, so can you.
Noted, it's on our list. Easement in the side yard, will address it in the submission.
Okay.
So those were the key issues, but we do realize that the threshold issue is the A finding and the interpretation of the rear yard, and pending a review of that, then you move into the D finding. So we have a clear understanding of the steps that need to be taken with respect to the application.
And I just want to throw in this other thing, which we have seen before. Let's just say, for argument's sake, that you have an easement. You don't necessarily have to provide a side yard. You could have a route of egress through basically a fire corridor and therefore provide no side yard. So because that's all it's saying, it's an emergency egress easement for, I guess, the neighboring property. Not sure why though. So you could provide a fire corridor and probably satisfy that.
We will provide additional information. I don't want to, my understanding with respect to that easement is that there are fire escapes on that building.
Yes.
And that is related to.
Right, but I actually have a lot of experience with this subject.
Sure.
So buildings department requires that, ancient route of egress to protect the fire escapes of the adjoining property. But as long as you go to DOB and you say to them, I'm maintaining the emergency route of egress, but this is how I'm doing it, they let you modify it.
So noted.
Right, okay.
Right. That would, and then depending on the provision of the side yard, it still would result in a very narrow as-of-right building with respect to the lot, but we can.
No, it wouldn't. It's only on the floor, on the level where you have to have your fire corridor, which even could be in the cellar, where they come in and they go down into the cellar and then they run across the fire corridor in the cellar. Or they come in and they run across the general corridor in the building to the front because it's only for emergencies. And then above that, you build full to the lot line. So you never created a side yard.
But that result would then make it a 20-foot wide building, which for a single family home might work, but it would be very unusual to have just a 20-foot wide building.
I thought it's 25 feet wide at that spot.
It's 12 and 8. When I look at the as of right drawing, it's 12 feet. It would be wider near the front, but near the rear of the lot, it's only 12 feet, the as of right building. So 12 and the additional 8 would be 20 feet.
But that's, I think the 12 feet in the rear, we are questioning how that is being arrived at based on the location of the rear yard determination. So that is,
No, actually, it's a 20, no. I'm looking at the drawings. It's a 50-foot wide lot and 25 feet of it is in that flag. So do the math, it's 25 feet.
The rear portion of the as of right building is only 12 feet wide.
No, but that's because the as of right building is using an 8-foot side yard. If you eliminate the 8-foot side, and I don't know if the measurement is correct because this is one of those simple things. If the width of the lot is 50 feet and the width of the flag is 25 feet, which I checked on the meets and bounds description, the remainder is 25 feet. So it could be the architect mislabeled 12 feet or I don't know what.
It's just the simple math. If you look at the
because
westernmost lot line is 50 feet or 49 feet and 49 feet, 8.5 inches. If you need to provide a 30-foot side yard, 49 minus 30 is 19.
Okay, so, but this is relying on the idea that you actually need a 30-foot bizarreness along there, which makes.
yeah, and
Sure,
I'm not
sure.
sure
No.
that's how the zoning reads it.
Agreed.
You know,
Understood. So-
especially Mr. Dale, I would suggest that when you look at the definition of 1210, you will see a graphics on that same page where it says lot line rear, lot line side, and then there's a lot through. And there it gives a diagram of the way the within 45-degree angle is being referred to. And if you applied that to your site, there's no way that side lot line can be considered a rear lot.
1210 definition. Okay.
Yeah.
I understand. How's this? I'm not disagreeing with the merits of really examining this issue. I've looked at this diagram and gone through this with the architect many times. And it was also discussed with the Department of Buildings many times. We will try one additional time to push forward with this, but and I appreciate you said you don't have the history of it, but this is not something that was ignored or done just in-house without Department of Buildings review. Obviously, if this could work out, it would benefit everyone, and we will try to pursue that. But I'm just explaining why the 23543 and 7369 weren't pursued based on primary review at the Department of Buildings with respect to it being a single rear lot line.
Okay, but you will do that. You will share with us the argument before it's submitted to DOB. Okay.
We can do that.
Okay. Good. All right. Let's open it up to the public then.
The application we are currently discussing is item number 24 on the calendar, 2020-55BZ, 1284 East 19th Street, Brooklyn. You wish to call in, it is 646-558-8656. Zoom webinar ID number is 979-3730-3967. The passcode is 390320. And if you're in the Zoom room already, please raise your hand by pressing *9 and *6 to unmute.
Okay. And I just want to say that, actually even reaching out to city planning on this question, because they're the ones who drafted.
Yeah, I was going to say, yeah, that's a good suggestion. Yeah.
Yeah. I mean, and this is pretty fresh in their minds. I think there are a number of people there who would remember what they had in mind.
We can do that. What may work better is if we can provide the language, if the board could assist with the city planning reach out, because
Yes.
that may be more difficult for us to initiate.
Right. Okay, we can do that.
Okay.
Okay, great. So how much time to respond? This needs some serious research.
I mean, we can be flexible with the board's calendar. I do think we need definitely some time. I don't know how long ZRD1s and city planning response would be. The remainder of the items, I believe, could be addressed concurrently with that, but it's definitely this threshold A finding issue
Right.
that's going to take the most time.
I'm thinking like 2 months.
That seems very reasonable.
Okay. Okay. All right then. I don't know if we see anybody in the waiting room. There's one person in the waiting room. If you're interested, Tony, you didn't read the case, I don't think, did you?
I did.
Oh, you did?
It's
Sorry.
2020-55 BZ, 1284 East 19th Street, Brooklyn.
Okay, sorry, I was reviewing something while you did that. So there's one person in the waiting room. If you want to be heard on this case, please raise your Zoom hand. Otherwise, what?
No, I'm just saying.
Just raise your Zoom hand because it's a Zoom caller. Okay, so 2 months to submit, and that's it then. I don't think there's nobody else on who has their hand up, so that's that.
There's
Okay,
a few people in the room. Oh, that's Jay's case. Never mind.
right. I think they're not related to this
There's a
case.
bunch of people for Jay's case. Okay. Item number 25, 2020.
Thank
Sorry,
you.
thank you. 2020-76 BZ, 8902 Fifth Avenue, Brooklyn.
Good afternoon, Jay Goldstein for the applicant. We have a number of members on our team today. With us is the architect and a member of the daycare's administration.
Who is?
Jeannie Cave.
Then you have Henry Radusky, who's the architect.
Jeannie, I'll try and go
Jeannie
through it.
Cave.
I have Jeremy Boyer as an architect. Jeannie Cave is from the school. Henry is the architect. Cheryl Swiker is from the architect as well. I believe that's it.
Okay.
Okay, let me raise your, swear you in? Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? And everyone, please unmute yourself that are part of the team and respond back to me.
I do.
I do.
I do.
Mr. Radusky?
I do.
Okay, thank you, Mr. Radusky. Please proceed, Mr. Goldstein.
Good afternoon again, Jay Goldstein for the applicant here on behalf of TLE, the Learning Experience. We attended the review session and we heard your comments. Madam Chair, with regard to the broker's letter, I have to go back and see what you're looking at, because I think what may have happened is, since we're not voiding the way we used to void, some of the older materials which I amended during the course may have stuck around. So I just have to clean it up and see. What I've done on my last submission, as far as my records go, I provided you a broker's letter, much in the way of the direction the board's given me on other cases, where we looked at a large area, not just the catchment area where we assume our kids are going to come from. We looked at a larger area and we found a number of sites, and we went through those sites. You could see I have an alternate site study map that I submitted in my last submission that has 3 sites located. I give the address, the block lots, the zoning districts, and then an explanation of the viability. So 2 of which were within close proximity to another one of our locations, and one of which is a building that's not built yet, and the price per square foot of that building as proposed, it happens to be handled by the same broker, is going to be $75 per square foot for the upper floors. So all that's discussed in the broker's letter and in my statement of facts. I'm not sure what other documents you were referring to, so I have to go back and see.
Right, so those were documents submitted like in September or something like that. And
Yeah.
you know, I was like traveling around looking for things. So it was a September 25th submission that had setup. So it was actually very nice because you could see exactly what the site looked like. And
So
then
I can provide you, okay, so that was the older submission. We revised that based on the comments I've received from the board and based on the notice of comments from the board. So again, that would have been voided in our,
Yeah,
you know, in our- so
sorry,
that-
I apologize. I think I mistakenly only voided the September 25th broker's letter, but I think I mistakenly did not void the alternate site study map and alternate site property printouts chart.
So what
we
was
can go
great
back.
about that 925 submission is it included setups of the building. So you visually,
I have them, I can submit them.
yeah, please. So
Okay.
'cause only one of them, it's true that two of them wouldn't have qualified in your study because they're both in C8s, whereas one was used in your later study because it's the one on 9201 Fifth Avenue. It made it into the later study, and the conclusion was the building's not built yet, and we need this now.
We also included in my later study 2 additional properties that were in as-of-right districts, potentially could have worked. However, they're within close proximity to our other locations.
Right.
So
Okay.
I can give you the setups for the 3 that are in our most recent. I'll work with Ms. Pranga to make sure that all voided materials are voided so that we're all looking at the same thing. But I think based on this, I think this is what the board was, the direction the board has in terms of alternate sites. So I believe that we do satisfy it. I guess at this point I can talk about Commissioner Sheta's comments though. So he had asked, where did we get the numbers from, the 13,500 square feet? So Commissioner, 13,500 is the amount of space that we're proposing in our proposed building. So when looking for an alternate site, we utilize that number as what we would need in an alternate location to satisfy the programmatic needs of the school.
But isn't that backwards? Isn't
Well-
it that you went to a broker and you said to the broker, I need 10,000 square feet? And the broker starts looking around for 10, which is based on, this is a very experienced childcare center provider. So they must have like a standard that
My
they look for.
statement was backwards.
Miss Cave. Yeah. Go
Sorry,
ahead.
my statement was backwards. My statement is not that. My statement is that the 13,500 is the number we were looking for a site. And
But
therefore,
But that's what Commissioner Sheta wants to know. Where'd you get 13,000? That's a nice number. Where'd that come from?
Why
Miss Cave,
13,000? Yes.
okay.
Miss Kate is waving her hand, so please let's recognize her because she probably knows the answer.
No
I
problem.
do know the answers. So our typical standard building is 10,000 square feet to 11,000 square feet. That's our prototype, plus some area for playground. So in some markets, we actually go a little bit larger because columns, et cetera. In the New York market, we usually typically look for 12 to 13,000 square feet because of columns in the existing buildings and stairwells and elevators. So that's how they got to the 13,000.
Okay. So you give a little extra fat for vertical circulation, and because in other places it's a more horizontal site.
Yes, ma'am. It's usually a ground up and we can control the columns and where everything else is.
Mhm.
So while I have Ms. Cave here, we can.
Wait. Let me
Oh,
just
sorry.
finish. Let me just ask. So you said usually outside of New York, you're doing ground up, and here you're
Yeah,
not.
we do a lot of ground. In New York, New Jersey, we're doing a lot of buildings in downtown New Jersey. But in the suburbs like Wisconsin, we typically will have a building that's a ground up because there's land available and it's easy to find land and it's inexpensive. So that's our typical prototype.
Oh, okay. But here, obviously, land is not inexpensive, right?
Correct. Very expensive.
Okay. All right. Thank you.
So I guess as to the second question, maybe Ms. Cave wants to discuss it as well. We noted on the site on Fifth Avenue that they're requesting $75 to $45 a square foot, depending on the floor, which exceeded the budget that TLE was working with. she can discuss that as well if she, you know,
Yes, please.
she wants.
So how do you determine your budget?
So we typically take the construction budget that the contractor provides, and in this case, they gave us a preliminary, and it was around $4 million. And then we look at what the rent's going to be, and we look at the tuitions are in that particular market. If the tuitions are somewhere about 2,800, then we can usually somewhat afford to be in that city. If it's not, and we think we're not going to be able to have as many kids in that market, and our tuitions are going to be somewhere in that $1,200, we have to scale down what we can afford for rent. So we did a formula, and this building worked for us because they were able to get the construction down low enough to make the numbers work.
Okay. Could you give us something in writing about that? It's a very clear formula. Could you just give us something in writing about how you
Absolutely.
determine the size of the place that you're looking for? That's actually what we would normally ask for, is what was the criteria you gave to the broker, and how did you determine the criteria? So this is super helpful.
Great. We'll put something in writing for you.
Okay. We'll submit it as part of our next submission.
Yes.
So the next, with regard to, sorry, I lost everybody. With regard to the trash storage, hold on, I'm having computer issues. Okay, I'm back. With regard to the trash collection, I can give you an operational plan from the building, how it was determined that this is what, that they'll be able to handle the trash. If it seems implausible, we can work with that, but so far this was the ideal for the trash.
So actually, again, if Ms. Cave is representing how it's going to function, are you aware that there's a trash room for the school located in the far corner of the parking garage, far away from your internal, I mean, there is no internal stair that takes you there and no internal elevator that takes you there. So I'm not sure how that's going to work.
So I'm not sure yet either. The trash was one thing that we have not discussed. So Jay, like to hear what the building proposes, and we'll figure out something. But Claire, Chair, Miss Chair, we have not addressed that yet.
Okay.
Just as way of discussion, the trash in the cellar was designed to accommodate the entire building based on the architect, based on the discussion. So we can discuss a operational plan with Ms. Cave and give you the information.
Right.
If it has to change, we'll change it.
Mm-hmm.
With regard to the number.
Can I just, sorry.
Go
I have
ahead.
a question on the trash, since we're on the subject of trash enclosure. Did you consider providing the trash enclosure under the staircase, the stair that is leading up to the exclusive staircase that is leading up to the second floor, providing a trash enclosure under there?
I did not, but Henry Radusky is on the phone with the other architects as well, and we can look at it and explore that option.
Because, yeah.
I'm Henry Radusky. I'm not so sure that would be something that the DOB will allow to happen in case there's some sort of fire or smoke coming out of that garbage, and it may hinder that stair going upstairs. So, I mean, it's something we could talk about. I'm just not sure that DOB is going to allow that to happen.
Right. But actually, I want to bring up that we had another one of these childcare centers where, and I always think of Mr. Goldstein as sort of the expert in how you do the trash calculations, because he's the one who came up with this calculation that all the other applicants now use. And so in this other application, they found these very small kitchen-based compactors they look basically like small refrigerators, like under the cabinet refrigerators. And that's what they ended up using for a daycare that was maybe a little smaller than this one. I don't really remember how many there were.
That's not my location. It's not my application, but
No,
I can
it's
ask Stella
not.
for it. I can ask Stella for the information and we can explore it.
Okay, isn't that Steve Sinacori's case, Tony?
No, isn't that Fred's?
No.
No,
No.
it was, one was Eric Platnick and the other one was Frank Shajak's.
That's
Oh,
it.
yeah, Frank.
Yeah,
Sinacori.
yeah.
Yeah,
Frank Jacks, yeah.
I can ask Frank as well.
Yeah,
Okay.
yeah.
Next, if we're ready, with regard to you asked for the chart on the plans doesn't show the room numbers. we actually did it a little differently because of the way the DOH works with the age groups of the students. So we break it up. The chart actually correlates to the plans. You see on the plans that it says infants, that there's only one infant's room on the chart.
I know, but that means you have to like read which is infant, which is not infant, just number.
I'll add another column and add room numbers.
A room number. That's how it's done. It's architecture, right? Numbers.
Correct. So when you're dealing with DOH and the different.
We're not dealing with DOH.
I'll add a column, no problem.
Okay.
Column and labels, you got it.
Okay.
With regard to the next two questions of the play area and the elevator without access, those are, I think, questions, as Madam Chair mentioned, for FDNY, and I'm happy to work with Chief Daly to address them. And if there is a problem with the access the way it's proposed, we'll modify it accordingly.
So I'm not sure if it's really FDNY, it could be building department, but at the moment I'm very concerned about children in the middle of the path of egress with all those toys and stuff.
Right.
And also going through another room to get to a second means of egress. You may not be required to do that because it's not a public assembly at that level, but certainly you're going to have the people from upstairs running through the play yard in an emergency, tripping over hysterical little kids and all of the playground equipment.
So we'll address the comments.
Yeah, I don't think it's going to be allowed.
Um,
Curious because you have architects, you have a lot of architects on this call. Have those architects looked at that question?
I think it's something that we discussed actually a little differently. We discussed it in the context, actually, of the last couple of days in the context of COVID as well. If we want to keep, I know with my kids, with the way my children's daycares are run, that they keep the rooms isolated anyway, so you wouldn't want to have it going through one classroom to get out to the play area. So it's something that we, during those conversations, will actually be addressed here as well.
Okay, but that's a different question.
No, but it'll resolve your comment of accessing the play area through the classroom, because we won't do that anymore.
Right, but you might still, the only other way to get there seems to be to go through the fire stair, which I'm not sure, well, you have to go through this other room to get to the fire stair. I'm not even sure you're allowed to go to the other room to get to the fire stair is the point, because that's your route of egress to the side. And then the other part of it is it's everyone's route of egress in the whole building. It's their second means of egress through the side.
So I don't think this is something that they may not be able to address on the spot. So I think
no, of course
they can if they want, but I think we'll address it in our submission.
Okay.
With regard to your next couple of questions regarding the EAS, I apologize to Tracy and to Jello. There was a little bit of a back and forth to try and expedite the EAS, where they thought I was going to wait on air quality and noise. In fact, we did submit in February the full EAS with completed air quality and noise. So I apologize for the confusion, but it can be sent out or reviewed and sent out. Commissioner Shanda, with regards to the site plan, we'll show, or we'll clearly label the elevator to the garage, which, as the chair noted, is on 5th Avenue, not next to the entrance to the daycare. But we'll note on the site plan on the first floor and on the cellar the elevator, the elevator for the cars. Then the next couple of comments were with regard to the concerns about traffic. We understand your concerns as noted in the statement of facts. We actually intend to try and get a no standing zone from DOT, either for a full day school days or for morning drop off and dismissal, which should resolve a lot of the comments and questions from the board about double parking. The school has a policy, and I guess Ms. Cave can speak to it or confirm it, that the students have to be, since especially given their age, have to be walked into the school and picked up by a registered or a recognized person. So the kids can't go in by themselves, can't come out by themselves. They have to be accompanied into the school, which is a safety precaution that most childcare facilities have.
Correct.
But so what prevents the parents from doing, as Commissioner Shabeta suggested, parking, let's say double parking or triple parking on 89th Street and running like mad to bring the kid in and then say, here, you take him?
Yeah, it's more complicated than that because they have to sign the child in, and with COVID, we require them to take their temperature, and there's some documentation that they have to fill out, and sometimes the parents have to wait 5 or 10 minutes because of social distancing, and there is a computer login as well, and when COVID's over, the parents are required to come in and do a computer login. So they have to log it in, and they have to take the child to the class once COVID is passed, if that's the case. And they have fobs into the space that they're required to use. So it's much more complicated. With COVID, it's even more complicated. So they'll be standing outside. They cannot leave a kid unmanned or by themselves. They have to be brought all the way in and given to a teacher and brought into the classroom.
Okay,
so that takes about 10 minutes.
And so,
okay.
we're gonna have someone.
Question, so the parent does, or a guardian doesn't take the child inside the building, the person hands it over to a teacher, correct?
No, they have to come in, the parent must come in, sign the child in, the temperatures must be taken of the child and the parent. Parent has to sign documentation to say the child they have to also verify the child didn't have COVID. And then later, once COVID is passed and everybody is immune, has their vaccinations, they come all the way into the reception area, and there's a computer that they'll have to sign in and do all the same stuff on the computer. And then they're given to the teacher in their classroom. They actually physically have to walk them to their classroom.
Okay. Mm-hmm. Hopefully you won't need to do that as a permanent thing, though. So there'll be some reduced version of that without the thermometers, I guess.
Correct.
So I think that is my question. Under normal circumstances, absence of COVID, how would this transfer happen?
So without COVID, they come into the reception area, they sign into the computer, sign the child in, sign themselves in, so that we know which parent actually dropped the child off. If it was the mother or the father, because there are a lot of divorced families and everybody wants to know who dropped the child off and who picked the child up. Then at that point, once they've done that, once there's no COVID, they will actually scan in past the next door and take them directly into their classroom. Right now, they go to the reception area and the teacher comes out right at the door and takes the child at the door. And when COVID's over, they will take them all the way down to the classroom.
Okay, so no matter what, it's always into the classroom. Okay.
Thank you.
All right. Thank you.
I believe that was all the questions. I'm not sure if anyone has any other questions for me.
I think, okay.
Jill, still have your hand up, Jill.
Oh, I'm sorry. That's left over from before.
Okay. So I didn't find still and I'll have to review it for the next time, the traffic study. But that's one of the concerns, obviously.
I guess it'll also, we haven't gotten comments on it yet, so I imagine that'll change as well based on comments.
Okay. All right. Anything missing, commissioners? Any questions not answered?
I just have one question for clarity in terms of the alternate site search. I'm going to provide you with the three sheet, whatever you call them.
The setups.
There you go. I'm not a broker. I'm going to provide you with the setups for those three sites to back up what we've provided.
Okay, and Ms. Cave is going to give us her carefully worded criteria analysis that really cleared up a lot for us.
Yep. I'm going to send that to you, Jay.
So it's two versions. It's the area that's determined based on allowing for vertical circulation and all of that. And then the financials, how you sort of back into it based on tuition and so on. Right. Okay, great. Thank you. Very helpful. All right.
I do have a question. I actually did look at the secret thing, and the question that I had after looking at the arrival and the dismissal and the breakdown of it was according to the statement, you've said that 30% will arrive by public transportation and rest would 40% walking, 30% by public transport. So I just wanted to know how the 30% that will be arriving by public transportation will be accommodated on street or in that curb area where DOT permission would be sought for
Private transportation or public?
Yeah, no, you mean private transportation.
private transportation.
Yeah,
So
private
the text says 40% of the children will arrive by foot,
Right.
30% by private. So I'm assuming that 30% is the vehicle. I'll be bringing my child in my own car. I'll have to park my car and then drop the child off. So that's the analysis that I felt was not quite clearly laid out in the SECRA or in the statement as to how that 30% auto driven parents or guardians, where will they be parking? And my concern is, I definitely don't have the information for the daytime, but definitely in the afternoon, I'm more concerned because that's when that area is active. And this would be a medical facility, I'm assuming. So its service hours of operations are somewhat is going to conflict with the daycare hours of operation.
Okay, I understand the comment. I'll address it.
So, thank you.
Okay, thank you.
Did
So
we discuss the stroller storage? I might have missed it.
it
I
is.
don't-
No, thank you. No, we didn't.
Oh,
Strollers.
Jeannie can discuss this as well. My experience is that strollers are taken with the parents, so I don't know what Jeannie's experience is.
So a lot of times we have, parents do leave strollers. We have an extra closet there that we're looking at. We did have a stroller room on there, but we had to move some things around to accommodate some other things. So I'll get with Cheryl and Jeremy and we'll look at if there's any room for another stroller room. It doesn't have to be big because most of the strollers pack up and they put them on hooks and they just push them all together. We do have quite a few that are small and can accommodate quite a few strollers. So we usually have one in this area. We'll look at it.
Okay, yeah, so that's a requirement. We've had some cases where the entire sidewalk is strollers. And you actually need to cross the street in order to use the sidewalk because it's just stroller land. So we're trying to eliminate that hazard. Okay. All right then. So let's go to the public.
Am I mute? No, I'm not mute. Okay, this case that we're discussing currently is 2020-76BZ, 8902 Fifth Avenue in Brooklyn. Say TLE, proposed TLE daycare center.
So you're gonna say, what do? You call.
It's call in 646-558, give me 8656. Zoom webinar ID number is 979-3730-3967. The passcode is 390320. And if you're in the Zoom room already, please raise your hand by pressing *9 and press *6 if you wish to unmute to speak.
Okay, there's no one in the Zoom room. Let's see if anyone shows up. So, and with respect to the strollers, just like with the trash storage, please provide calculations on how many strollers fit in there because
Okay, I'll turn to Ms. Cave for guidance on that because we're forced to take our strollers with us. So
Right.
I'll have her give me some guidance.
So there's supposed to be 152 children, so you have to assume more or less that many strollers of different types, right? So, yeah.
No, there won't be that many because some of the kids are older. We go all the way up to pre-KK. So there'll be less, but we'll let you know like the age range which the strollers usually are in.
Okay, perfect. Thank you. All right. I don't see anybody with their hands up. So how much time do you need to respond to these questions? And also we have seeker issues.
I don't need any time at all, but we have seeker issues.
Well, you do need, because we need submissions. So it's not that
I'm saying my submission can be quick, but I think we have to go based on what seeker timetable is. So maybe Tracy can guide us.
Well, it's also not just a secret timetable. I have a significant fire safety.
Oh, the fire safety question, right?
So,
Okay.
I would like actually DOB to take a look at fire safety because you're making assumptions about play areas and all of that, and you may not be able to use this.
Okay. So I need 3 weeks, I believe, to get that.
Okay. And
Right.
Tracy, what do you think?
Sorry, I'm having some childcare issues of my own.
Oh.
Yeah, I think it turned out we did send this to DEP for air quality noise. It's a little confusing, but we have to check with them because they're having delays on their reviews right now. So we might get something in April.
April. What what does your comrade think about that submission date? So April would be the turnaround is what you're thinking? Well, we're almost there, right? It's 23rd.
April will be to me, so it's just probably 6 weeks or so for me to respond.
Okay, so 6 weeks to submit or longer?
I mean, because yeah, that should be. It really depends on DEP, so I don't know. So I can't answer it.
And I'll put 6 weeks to submit.
Yeah, I'll do my best based on when they get me their comments.
So when we send out the proposed dates, see if you can clarify a little bit more, because the worst is, of course, then
100%.
adjourn in 9 weeks, and then we adjourn, the outside adjournment date is 2 months later, kind of thing.
No, I know. When you send out the proposed dates, I'll follow up with Tracy to try and figure it out.
Okay, good.
Okay.
All right. Thank you very much. So
Thank you, everybody. Happy holidays to everybody.
Thank you.
Bye.
Thank you.
Okay. Bye-bye.
So, there's no one in the room, so this concludes the public hearing for March 23rd, 2021, the 2 p.m. session.
Wow. Enjoy the rest of the day.